Hi guys, I hope you're doing well. So today we are going to discuss how can you handle a criminal case to make sure that you come out on the winning side. I want to remind people here that it is the prosecutor who is supposed to prove your case beyond reasonable doubt. If you are being charged for murder, it is upon the prosecutor to make sure that he or she has provided enough evidence to show that you committed the crime. They have to prove that you committed the crime beyond reasonable doubt. With that said, when it comes to the hearing of your case, it is not your job to play defensive. It is your job to challenge that evidence that the prosecution has provided, to cast doubt on it, to show the court that whatever this prosecutor has produced before this court is not enough to charge me for murder. That is your work. It's not for you to start saying I was with this person. No. You have to show the court that the evidence produced by the prosecutor is not sufficient to charge me for that crime. So how do you challenge the evidence of the prosecutor? You look at the witness statement that person has produced. You look at the expert reports that have been produced. You look at the exhibits. You look at any kind of legal process that was done by the prosecutor and ask yourself, did they actually follow the process with the latter? If for instance they were trying to obtain evidence, you need to ask yourself, did the prosecutor follow the appropriate legal procedure in obtaining evidence? Was the evidence obtained legally? Because evidence that has been obtained illegally cannot be admitted in court. So you need to ask yourself those kind of questions. You need to ask yourself, was the identification parade done properly to actually identify you as the perpetrator of the crime? So you need to ask yourself, were those rules for identifying you as the perpetrator followed? So you question things like that. If let's say the prosecutor has got a CCTV footage, you need to ask yourself, that footage, has it been properly adduced in court? Because there's a way you adduce electronic evidence. It's not just like a witness statement. There is a way that you produce electronic evidence before the court. So now you need to ask yourself, has the prosecutor followed that process? If it is expert report, you need to sit down and ask yourself, this report, where can I challenge it? You need to do some research before you go for the hearing. Where can I challenge this report? What is wrong with this report? You need to look at it. If it is forgery, you need to question every document. Remember, it is either the evidence is direct or circumstantial. If it is circumstantial, then you need to look for loopholes. Look at the witness statements. Is there any inconsistency? Is there any contradiction? Anything that can just point out that you may not be the person who did the crime. So then it means you need to keenly look at the witness statement, word per word. Look at the timing. Look at the date when the crime occurred. Look at the circumstances under which the crime occurred, It's good when you're reading these things, you visualize it in your picture. Now for advocates, you actually visualize it. You look at it and you're just like, can this actually happen? A crime is committed at night. What are the circumstances? Was there proper lighting? If someone is saying, I saw you. Was there proper lighting to actually say that this person properly identified this person? So you need to ask yourself those kind of questions. Before you even think of defending yourself, you need to properly challenge the evidence that has been adduced by the prosecutor. You also need to look at the charge sheet. Is it even disclosing an offense in Kenya? That charge sheet, is it even disclosing when the offense happened? The timing? If somebody is accusing you of stealing, the charge sheet is saying that Anifa stole 50 kilograms of unga. But the exhibit produced before the court, we are only seeing 2 kilograms of unga. The complainant in his witness statement is saying, I only bought 2 kilograms of unga. So now how are you going to explain to the court, how did you end up getting to the valuation that I stole 50 kg? When the complainant is saying it is 2 kg, the exhibit is showing 2 kg. So how did we get to 50 that you are writing on the charge sheet? With that, we will actually know that you are trying to lie. There is no exhibit to show the kilos of unga that I stole. You have not produced that before the court, and you want me to be convicted of stealing. It's not going to happen. So for you to note that, you have to look at everything that the prosecutor produces. If let's say it's a ballistic report, we are trying to analyze bullets, you need to ask yourself, the one that was recovered and the one that is in the report, is it the same? It could be that the one that was recovered and the one that was in the report, they're not even the same type of bullets. So those are the things that you're supposed to look at. Which means before you go for that hearing, you really need to sit down with the advocate, go through the evidence of the prosecutor properly,